All right, hello, welcome to another criminal law capsule, and today we're going to be talking about routes of appeal in criminal cases. This capsule is designed to give you a good overview in the way in which defendants or the Crown Attorney can appeal in particular decisions, and it's going to go through a number of things just to give you a basic overview of the way in which appeals takes place. So I'm going to look at three particular subjects here, although not quite broken up in this order. These are the three things I really want to get at. One are, obviously, I'm going to show you exactly how a defendant or the Crown can appeal and in what circumstances in a criminal case. I want to briefly explain through that process what it means to require leave to appeal and how that is different from an ordinary appeal. And finally, I'm going to give you an introduction, no more than that, but at least an introduction of the options that are available to appellate courts in order to deal with appeals, in the hope that that'll give you some broader perspective on the appellate process. So let's dig right into it. So to begin with, it is really important to keep in mind that there are two different kinds of appeals, or at least a better way to think of it, there's only one type of appeal, but there are two different ways in which you can try to appeal a particular ruling. So again, let's say you go through your case, you are convicted. How do you appeal that verdict? And let me say right off the top, I am only talking about appeals here that are what I call appeals after final disposition. And that is really important. And I say that because there are some other types of appeal that can be taken from particular orders of a lower court. And that is a whole other kettle of fish, and I'm not interested in that in this capsule. I am really only looking for what do you do where you have a final disposition in a case, and what I mean by that is it's one of four things. You are acquitted, you are convicted, you are found not criminally responsible, or there is a stay of proceedings in your case. Those are really the four things that I'm interested in. Anything else, there are particular rules that deal with those sorts of appeals, not of concern here today. So when you are appealing from a final disposition, as you can see, I've put up these two particular ways of doing this, and I want you to look at these arrows as I show you all the routes. So as of right is simple enough. When you have an appeal as of right, it means you can appeal without any further notice. Once you have essentially received your particular disposition, you have the right to appeal. Whether you do so or not is up to you, and in fact lots of times, especially the Crown Attorney, will have the right to appeal a particular decision, and they simply won't bother. It won't be worthwhile to them based on the merits of the case. But all I'm getting at here is that an as of right appeal is an appeal that you have a right. You have a right to that particular appeal. With leave appeals are more complex. What a with leave appeal means is that the higher court must grant you leave to appeal. In other words, there is what I like to call a preliminary bar to actually appealing. So this preliminary bar is that you must convince, depending on the level of court, if it's the Court of Appeal, you must convince usually an independent Court of Appeal judge that your appeal has some merit. This is essentially a way in which the court screens appeals. They do this to limit the nature of their docket, because essentially if they didn't do this, if every appeal was as of right, higher courts would have a great deal of difficulty controlling what comes before them, and they would be frankly overwhelmed in procedures. Now the Court of Appeal, as you will see, in any province has the right to dismiss some appeals unless leave is granted. There's actually quite a big range of appeals that they don't have to take, and you'll see that as we go through. But the idea of leave to appeal is most notorious for the Supreme Court of Canada, and the reason for that is very simple. The Supreme Court has 9 judges, and they are, of course, the final court of authority in Canada. If they did not have the ability to control their own docket and had to take any case that came before them, they would never stop sitting. It would be impossible for them to hear every appeal that that anybody wanted to bring before them. So the Supreme Court of Canada has a mechanism by which leave is granted by 3 judges. They sit in small panels of 3, and essentially they just review papers that are submitted by the appellants to see, is this a meritorious case? And we'll talk a little bit more about that when I get to Supreme Court routes. But obviously it's important at the outset to understand the difference between as of right appeals and those where you must seek leave first. All right, so you have a final disposition in your case. Where do you appeal? Well, the truth of the matter is that depends heavily on what type of offense you were being tried for. Now, in another capsule, I talk about different kinds of offenses, so if this is new to you, it's probably worthwhile to go and listen to that first. But essentially, all the criminal offenses in Canada can be broken down into two categories. There is a summary conviction offense, and there are what are called indictable offenses. And by and large, the basic separation between the two is that summary conviction offenses are for less serious offending, and the penalties for summary conviction offending is much lower, so you'd usually heard in a lower court, which is the provincial court, as opposed to the high court of a province being the superior court. Now, indictable offenses are more serious, but as you can see, you got to be careful. Don't just look at the judge, because provincial court judges in certain cases can hear indictable offenses too. And I want to be clear to you that just because you're being heard by a provincial court judge is not what determines your route of appeal. What determines your route of appeal is the nature of the offense and the procedure by which you were charged. So in summary conviction appeals, it's one thing, and in indictable offenses, it's a completely different procedure. So the best way to think of appeals as a whole are you get one free appeal. That's essentially true no matter which route you're in, although there's one minor exception to that. But essentially, if you are tried before a summary conviction court judge, you get a very liberal route of appeal to a summary conviction appeal court under Section 813 of the Criminal Code. You can appeal anything, pretty much. It's an appeal of law, an appeal of mixed law and fact. It makes no difference. You can appeal a conviction, you can appeal your sentence, you can appeal any ruling that was taken in the case. It's an exceptionally broad route of appeal. Effectively, if you're unhappy about something that happened in a summary conviction proceeding, you can appeal. And this is true for both the accused and the Crown. For the purposes of Section 813, both parties have identical routes of appeal. So essentially, one free appeal through to the summary conviction appeal court, which is essentially a single judge sitting in the superior court of the province or territory. And from there, it's with leave only. That's it. Section 839 allows you to try to appeal to the Provincial Court of Appeal, but you must get leave from that court before you can actually bring an appeal. And that's true for the Crown or the accused. Now, it's a little bit different from indictable offenses, believe it or not. Essentially, Section 675 of the Criminal Code allows you the same free right of appeal on any aspect of the law relating to your conviction, acquittal, finding of not criminally responsible, or stay of proceedings. And that is also true for the Crown or the defense. So everybody gets a free appeal on the merits of the trial. I guess the main difference between indictable offending and summary conviction offending is you don't get a free right of appeal on sentence. That said, let me just say that I've seen a lot of these cases, and the truth of the matter is most offenders, the courts of appeal are very reluctant not to grant leave on sentence. Essentially what they do is they hear the appeal, and then they decide whether or not they're going to grant leave. It seems like, I could be wrong in that, and there could be some jurisdictions in which they're a little bit more particular about it, but especially if you bunch up and you have an appeal, you just throw in one ground of appeal on the basis of conviction, then essentially, the court's already hearing the appeal. And at that point, the idea that leave only is going to be required seems to me to be pretty, kind of insignificant. Most of the time that I've seen, the court will hear the whole appeal and just decide at the end whether they grant leave or not, which seems to, mean that it's pretty close to an as of right appeal, even on sentence. So what's next? Well, Section 691 of the Criminal Code says, that's what governs the right to appeal to the Supreme Court of Canada from a Provincial Court of Appeal. And the first thing to recognize is that section refers only to indictable offenses. And that's really important because, as you'll see, there are certain situations in which you actually get what's called an as-of-right appeal to the Supreme Court of Canada. But those sections do not apply where you were originally tried with a summary conviction offense. So Section 691 applies only to indictable offenses. For every other type of offense, summary conviction, you've got to apply for leave just like every other case that there is, and you essentially do that through the Supreme Court Act. But that's not really of importance to us. The basic idea is you need leave if you're going to get route to appeal to the Supreme Court of Canada, and that's true, Crown, defense, doesn't matter. Now, for the vast majority of cases, that's true for indictable cases too. But as you're going to see, there are two situations in which you get an as-of-right appeal to the Supreme Court of Canada. And here's what they are. There are essentially two, although for the Crown, as you can see from this, it's only one. The first is that there is a dissent in the Court of Appeal on some legal position. And that's really important. Essentially, the reason I think that number one exists is simply to recognize that where there's a dissent in a provincial court of appeal, which is the highest court of appeal in a province, essentially that gives the legal case enough merit that it's worth having the Supreme Court hear it. So essentially, if you're the Crown or you're the accused, and you manage to convince one appellate judge that your position has merit, that warrants, or that gives it enough importance, given the stakes of a criminal conviction, that it's worth having the Supreme Court of Canada consider the matter. The second situation is actually an interesting one, and it relates to the idea I suggested otherwise. If you remember earlier when I said you always should have one appeal from your particular case. You always have to get at least one. So the situation that arises where you don't get at least one is if you get acquitted at the original trial, and then you get to the Court of Appeal, and we'll talk about how this is done in the next couple of minutes. But essentially, the Court of Appeal looks at it and says, no, your acquittal was not correct, and moreover, we have to convict you. Well, if you think about what just happened there, no matter how meritorious that might sound, and no matter how meritorious, the grounds of the Court of Appeal for convicting you are, they might be crystal clear, yes, you got convicted. The truth of the matter is, you never got an appeal from your conviction. If you think about it, because you were acquitted here, and then you get here and you're convicted. So the basic idea is you should get one try to convince a higher court that that conviction was incorrect. So that's why in that situation you get an as-of-right appeal to the Supreme Court of Canada. Those two situations are the only in which you have what's called an as-of-right appeal. Okay, so you've got your appeal, or you've gotten leave to appeal to the higher court. What happens now? Well, a critical section of the criminal code, which you need to study if you're ever going to become any sort of criminal lawyer, is section 686, which sets out the ways in which a court of appeal can act. It effectively defines their powers and streamlines situations in which the court should allow or dismiss an appeal. So let's start with the first one. When should an appellate court allow an appeal? And I should say, even right now, you're going to come in the next slide to when does the appellate court dismiss an appeal. The three situations I'm about to outline are situations in which the court can allow an appeal. So when can the appellate court allow an appeal is probably more accurate than when does it. So just because you meet one of these three, as you'll see in the next slide, doesn't mean that you're going to get a new trial or, they're going to reverse a particular aspect of the case. Except, of course, when you succeed in this ground of appeal. This almost always gets you a new trial or an acquittal, depending upon the situation. And that's unreasonable verdict. And I won't, I could spend all day on what these means, and there is a lot of case law out there to go through this. But to make, to give you a brief overview, let's just say that it's a high threshold. The idea of an unreasonable verdict is you are contesting what happened either at your trial, or, what the judge did at your trial. So you're saying that the jury was unreasonable, or the judge was unreasonable in reaching the conclusion they reach. And what this really means is, unreasonable means it's not supported by the evidence, or, given the burden of proof beyond a reasonable doubt, it's simply unreasonable to say that the jury would have met that particular requirement. Now, again, I don't want to spend all day on this, but just thinking about it for a moment, you can imagine that an appellate court is not going to do this lightly. They are essentially going to look. They were not the fact finders. They didn't hear the evidence. They didn't weigh all the evidence. They will certainly look very carefully at the evidence, and essentially what they'll say is, look, could a jury or trial judge, could they have reached this verdict? And to be truthful, it's only when there was no way that they could have reached that verdict that you're going to find an unreasonable verdict. And that makes sense. We don't want appellate courts coming in and picking apart jury verdicts or trial judge verdicts, after weeks and weeks of trials. It just would not be very economical to do so. So effectively, they will look at it, they will review it, but you've got to convince them that the verdict was one that could not have been reached. Now, much easier to understand is there was a legal error. And the legal error can relate to anything. It can relate to the court unreasonably admitted evidence. They didn't follow proper procedure. Perhaps they didn't instruct the jury correctly on the elements of the offense. Perhaps the trial judge didn't apply those elements correctly. Perhaps the trial judge, didn't allow a defense when there should have been a defense present. Really, the list goes on. Legal error is obviously the most common way of allowing an appeal. Just even right now, I put a little asterisk. Not every legal error gets you an appeal, as you will see in the next slide. It's not true, but nonetheless, legal error is the best way to get started the process of getting the court thinking about granting you an appeal. And the third is sort of a catch-all category. The appellate court has the ability where they want to prevent a broader miscarriage of justice. So there wasn't necessarily a legal error, and there wasn't necessarily an unreasonable verdict, but something has happened that really, brings the court a great deal of concern. And the easiest one to think of in terms of, miscarriage of justice is perhaps the Crown, after the fact or whatever, did something that was really heinous, or there's something has just brought taint on the proceedings in a particular way. Well, the verdict wasn't unreasonable. There might not have been a legal error by the trial judge in the way the trial was run, but something that's taken place is kind of smelly. So it's sort of this residual catch-all category that doesn't come into play all that often, but it's there. It's there to allow the appellate courts to do what they need to do, which is to make sure miscarriages of justice don't occur. And that's essentially what happens. I could go on. There could be lots of things. Another good one is, what if the crime itself is repealed? By the time the guy is convicted, and then a week later Parliament says this offense is no good. We're gonna repeal this particular crime. Well, there's no unreasonable verdict, and there's no legal error. But maybe the court says, we're going to allow this anyway because it would be wrong. Parliament has signaled this is not a crime anymore. We'll allow this appeal to take place. We'll vacate the conviction. I'm just giving you examples of the sort of situation in which number 3 might come into play. Okay, so when do they dismiss an appeal? Well, number 1 is the easiest. There's no error. Obviously, if you don't meet 1, 2, or 3, there's no reason to grant an appeal. And here is the most important, and this is one you really need to look carefully at, and if you're ever doing an appeal, you got to be ready for what's called 686 sub 4b3. That's, the actual section that says there is no substantial wrong or miscarriage of justice. Now, why do we have this section? It's very simple. Trials are long, lots of things happen, errors take place. So essentially, if you were going to allow an appeal every time there was a legal error, it's quite possible that no trial would ever complete. Now, that's an exaggeration, but I think you get the idea that, during the course of a trial, the chances that a judge does one thing or another that's wrong is fairly high. They might not instruct properly, they might have forgotten to do X, they might have admitted one tiny piece of evidence that was wrong. We can't allow every appeal in which there's an error. Just the system of justice would literally grind to a halt. So, we don't. We just don't. What we do is we allow appellate courts to dismiss where the wrong was not substantial and there was no miscarriage of justice, one or the other. And essentially, what this means is the court will look over the substance of the error and they'll say, look, again, this is more complicated than I'm letting on, but I'm trying to give you just a basic overview. So, number 1. Is the case against the accused, or the case in favor of the accused, depending on how the error went, overwhelming, right? If the case was overwhelming, then it didn't matter. The error didn't matter. And I've seen that happen many, many times. You get this piece of evidence was wrongly admitted. Okay, great. The trial judge clearly erred. But the rest of the case was so overwhelming, there was no way this guy was going to get an acquittal. Therefore, appeal dismissed. That's number 1. Along that line, or along those lines, is another way of doing it, and it's essentially saying, okay, the case may or may not have been overwhelming, but it was a pretty good case. But it wasn't overwhelming. The standard of overwhelming is high. But the error in itself, in context, was minor. So yes, there was an error. But the error didn't make that much of a difference. So again, it's the same idea. You're just not focusing on the rest of the evidence. You're focusing on the gravity of the error. You know what I mean? So there was an error, something went wrong, I don't know what it was, but the error was not substantial. And that is essentially what you're saying. So these are really the 2 most common situations in which this takes place. And let me say, they're very common. They happen a lot. It's the way in which appellate courts control appeals. And the third situation, which I actually don't think is separate, but it's there anyway, I think it's really a derivative of number 2, no substantial wrong, is where the error was simply a procedural irregularity. It's that, something went wrong in the trial, and there was, an error of some sort, but essentially what happened really doesn't relate to the trial in and of itself. It really is just a procedural matter that didn't affect the trial, which is why I think you could fold number 3 directly into number 2. But I guess conceivably there are situations in which a procedural irregularity should be treated separately. In any event, if it's just something small and technical and procedural that didn't affect the substance of the trial, no matter how grave the mistake might have been, if it didn't affect the substance of the trial, it's improper to allow an appeal on those grounds. Now, I just want to finish up with 2 particular matters that I'm going to touch on briefly that I think are fairly important. And the first is the issue of remedies. Now, to be clear, the courts of appeal and the Supreme Court have a broad array of remedies at their hands. There's actually a lot they can do. And when I say there's a lot they can do, that's not the same as saying there's a lot that they will do. And what I mean by that is, let's say you have a guy who's convicted. Okay? So the Court of Appeal says, you know what, there's some merit to this appeal, we're going to allow the appeal. What they do from there will obviously depend greatly upon what the appeal is. If it's just a sentence appeal, they may just adjust the sentence. But let's assume it's a conviction appeal going to the actual conviction. They can order a new trial, or they could just acquit. But they don't just decide one or the other by flipping a coin. Essentially, what they will do is look very carefully at whether it's a good idea to acquit or whether it's a good idea to order a new trial. And again, I could go on about these particular things at length. The key really to deciding what the court will do as a matter of remedy will depend heavily upon the nature of the error. So, for example, where it's an unreasonable verdict, and the guy was charged and he was convicted, and the court looks at it and says, look, the evidence is completely incapable of supporting conviction. Well, the court's not going to order a new trial. They're going to say the evidence the Crown brought wasn't good enough. They're most likely going to acquit. That's just the end of it. But in other situations, the court will say, okay, this evidence, let's say they allow an appeal on the bounds that, a wrongful, some piece of evidence was wrongfully admitted. So the court, made a decision. The jury made a decision based potentially on evidence that should never come before it. So the court will then look at it and say, okay, that evidence should have been excluded. But what do we do with the rest? They will then assess the evidence and say, well, look, we can't be sure what the jury would have done without that evidence. They may have acquitted, they may have convicted. So therefore, that's a classic situation in which a new trial is going to be ordered, because they'll say, well, we got to go back and hear it. It's not up to us to become the jury. So they will generally order a new trial. That's a very simplistic view of the way this takes place, but essentially, let me be clear that the courts have the power under the criminal code to do almost anything. They have a wide variety of remedial powers, but generally speaking, when it comes down to new trial or acquittal, the question will be whether, if you take the error out, was there enough there to go forward? That will essentially, in a nutshell, sort of decide what will happen. One last point on this. 2 last points. First, 1 point. First of all, one thing the court will decide in ordering a new trial or acquitting is they will also look, and by the way, this goes to error of law and whether or not they're going to dismiss on the grounds that, there was no miscarriage of justice. They will look at who's making the appeal. Who? And they'll also look at who decided the case, a jury or a trial judge. To make a long story short, where a person's been acquitted by a jury, the bar is a little bit higher for the Crown to get a new trial. And I guess the reason for that is that, a person's been through this, and they want to be clear that the jury verdict really would not have been the same without this evidence. And as you can imagine, where it's the accused who's appealing, the court is a little bit more careful, because obviously the accused's liberty is at stake. If it's just the Crown who wants another crack at this guy, they're going to only do that when it's really sure that there's good grounds and this has to go back for a new trial, because essentially it was done improperly. Where it's the accused, generally speaking, the Court of Appeal will open that door a little wider, because they want to prevent miscarriages of justice and people from being wrongfully convicted. So I just keep in mind who's doing the appealing, because that's an important part of this process. Last point, and this is an important one, but a really small one. I just said the Court of Appeal or the Supreme Court can order a new trial. just keep in mind, it's actually not all that uncommon for this new trial to, never take place. It just doesn't take place at all. Because ultimately, when the Court of Appeal orders a new trial, it doesn't mean that, they say, well, a new trial must take place. What they say is that the Crown is entitled to a new trial. Now, keep this in mind. It's different if it's the accused. The accused, doesn't have the choice as to whether the new trial will take place. But let's say for a moment that the Court of Appeal says, no, there was an error, new trial ordered. Ultimately, the Crown must decide whether it's worthy to take a new trial. Like, they have to decide whether that's worth it in the circumstances. And that is a complex decision. Like, that is a decision that requires an assessment of a bunch of factors. But let me just say this, very briefly. Sometimes the Crown takes appeals, and it does so because it feels that the point of principle or the point of law, because this is a common law system, the legal finding in the case is wrong, but doesn't necessarily pursue the new trial. They'll say, okay, we won. We got a new trial. The guy was acquitted. That was wrong. New trial ordered. But then the Crown walks away from it. Another reason why the Crown might walk away, and this is actually not uncommon at all, and there's a case or two that we study in this course that covers that, is a situation in which the guy's already served his sentence. Like, he might get a short sentence, and he's sentenced, for 3 months in jail. So he goes and serves them while he's preparing his appeal. He doesn't get bail pending appeal because, so he serves his whole sentence, but he doesn't want the conviction on his record. So he goes up and he appeals, and he gets the appeal, and he wins the appeal. He's granted a new trial. And the Crown looks at it and goes, yeah, whatever. He's already served his 3 months. We got what we needed in terms of penalty. So that's another situation in which a new trial might not necessarily take place. But I stress to you, what I'm saying to you right now, none of this is legal. These are not legal decisions. These are decisions for the Crown to make. It's ultimately the Crown who decides whether or not a new trial will take place. So that's quite a bit on routes of appeal. I hope that was some use, and have a great day.